again, on the back.
But you hire and fire and supervise them. I mean, I guess what concerns me a little bit is the suggestion that, you know, while there might be practical reasons why the statute could have DOD be the operable agent here, it's not up to us, right? We're not just in the first instance making policy determinations about how this thing should be structured. And as Justice Kavanaugh just pointed out, we have a statute that gives these people, the dual service technicians, collective bargaining rights that in the collective bargaining world, as Justice Kagan points out, it means the right to sit across the table from the people who hire and fire you and bargain over the terms and conditions of your employment. So I guess your task, in my view, is to establish why it is that Congress would have intended to carve you out in this situation.
So let me first back up for a second and explain. It's important to emphasize the law we're interpreting here, the Reform Act, is not about National Guards and technicians. It's a generally applicable law for the federal government. And the word—
The law we're interpreting is the FSL-MRS, right?
That's the Reform Act.
Okay.
Same thing.
All right. Sorry.
Those statutes are generally applicable. They apply to the whole federal government. And the word in question is agency. So the federal, the authority has jurisdiction over us only if we are an agency. And if to be
But DOD is an agency, correct?
DOD is an agency, so
All
they
right.
can issue orders to the Department of Defense.
And DOD, per the statute that Justice Kavanaugh points out, has delegated to your entities the authority to hire, fire, and act in that capacity over this group of people who have federal collective bargaining rights, correct?
Congress has given us that power, though the Defense Department, we shouldn't minimize, has immense control over.
Understood, but why isn't that
even a
answering the
DOD
question?
choice?